and my 14th Amendment due process rights. I make a reservation for those rights, especially, but all rights at this time.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is appearing today in street clothes. He has a dress shirt and a tie on. He's also wearing a mask.
And I don't consent to being called that name for the record. As this paperwork I accept for value and return for value, as it does not state the correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Your objection is noted. It's baseless in law and fact, and that is simply a caption on a pleading on the final jury instructions.
That is not my name, for the record.
All right, the record should reflect, Mr. Brooks, I'm talking. The record should reflect that at 3:23 p.m. yesterday, all of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court will be reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first 73 pages this morning. I do anticipate having to take one or two breaks before I complete all of that. My plan is to do that and then take the lunch break. And then when we come back from lunch, to have the parties provide they're not opening, their closing arguments. And then following the closing arguments, the court has the final jury instructions, which go through the closing instruction, instructions 460, 484, and all of the verdicts, and then the instruction to the jury 515 about their verdicts needing to be unanimous, and then selection of a presiding juror. The very last page, 107, actually is not read until the close of the case, and only following receipt of verdicts or some other type of disposition that would result in the conclusion of the case. It's the instruction after the verdict is received. So page 107 is not something that will be read today. As indicated yesterday, I will be selecting the alternates by random selection. We'll use the tumbler and select 3 numbers out of that, but that will be done after all of the instructions are read and the parties have an opportunity to give their closing arguments.
Your Honor, I accept for value and return for value any documents that you just alluded to. I have not seen them.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can. The court retrieved the final jury instructions. I personally didn't. I had someone do it, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought out a little bit later.
There was a conference. We talking about the proceedings from yesterday, or after you had told us we recessed?
Mr. Brooks?
I'm referring to after you called recess for the night yesterday. That's what I'm referring to. I was put in the holding cell for over an hour because they said it was some paperwork that needed to be.
That is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties. And so that's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
Left them in what holding cell? In here?
I have to look through his paperwork to see if they're on here.
What holding cell are you referring to, Your Honor?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts?
Yeah.
All right, he has those. Thank you.
Is this the paperwork that was just put on my? It was paperwork on the desk when I came in. That was on top of my folders.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know.
That's
but they are also on your desk now.
I accept for value and return for value any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over an hour?
There was no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork based upon the discussion that was held on the record in open court yesterday.
I was told that I had to stay there per you.
Yes, so that we could provide them to you and you would have an opportunity to take them back to your cell.
But
should you wish to
can they have
review
been
them.
delivered to the jail?
All right. I don't believe there's any other preliminary issues we
There
need to address other than an advisement I will have for Mr. Brooks. But let me turn to the parties and ask if there's anything preliminary to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state.
No, Your Honor, thank you.
All right. Anything else from you, sir?
Yes, there is. Yesterday, I stressed to the court numerous times about me not understanding the proceedings, and essentially how decisions are being made on my behalf without my understanding or giving consent.
The court made various rulings yesterday. I made findings and ultimately made some determinations. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions were made when I was not present in the courtroom. I was in the other courtroom, correct?
That's true, sir.
Is that correct?
The record will indicate when those were made and where you were.
I can't see the record, though. How am I supposed to know what the record will reflect?
Sir, the decisions were made yesterday. I'm not revisiting them today.
They need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record. I'm still trying to understand, Your Honor, how you made a judicial determination on my behalf, which I did not give consent to, as you say, I forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to. But that decision was made for me. Also, the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I was ready to rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights. I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer, but I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand fundamentally? It's not me saying yes or no, and it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that,
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah. There was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think that's a fair request, sir.
If that pleases.
I think that's a fair request. I thought about that and some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone, if there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st, with kind of a proposed plan of how many people do you think will speak on your behalf, how long do you think it will take, so that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request that you're making.
Thank you.
All right. So with all of that then, sir, subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be, that's still not, I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence. Nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them, and to the extent that the record does not have meaning the record before the jury, and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir. What I will tell you is this.
How did I forfeit
this
the
jury
opportunity
is here
to be able to place into evidence?
Mr. Brooks, I'm not going to debate this further.
I'm not trying to debate. I'm trying to understand.
To respect the fact that I've made rulings.
Your Honor, that's you made a judicial determination.
It's not my job to explain them to you.
I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things into evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things that clearly help my defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks, I'm no longer going to talk about this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence
the filings that
or
I
the
filed.
rulings or
I'm
the
asking
law
a question,
to
Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings with this court are in the court record. That does not mean they're evidence, sir. And I told you that
That's not what I'm
previously.
asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
So they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with all respect, you told me that we were not at the evidence. When I said I have exhibits as well. I have stuff that I want to put into the record. I even asked, I said,
Mr. Brooks,
may I give an offer into evidence?
I'm going to stop you once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It should not be, though, Your Honor.
I understand your lack of consent. Your objection
so when would I be
is
able to
noted
put?
for the
When
record.
would I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings, and important paperwork and documents.
Mr. Brooks, and you forfeited your right to do that by your conduct yesterday, and I stand behind that decision. I'm going to do the following, sir.
Your Honor,
I'm going to do the following.
Before yesterday.
You have not honored my request to you that you cease debating me on prior rulings.
I'm not trying to debate.
Court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the record does not.
I am going to take a 5-minute recess. When I come back out, the jury will also be coming out. I'm advising you there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum and courtesy.
Just hold me in contempt then, Your Honor.
You are
hold
hereby
me in contempt, because I didn't even, I'm trying to seek to understand.
If you start talking about subject matter jurisdiction or any of these other issues.
It needs to be addressed,
or
Your Honor.
in any way
we're not talking about subject matter jurisdiction. We're talking about why my due process has been violated.
I will excuse the jury and you will be removed to the other courtroom.
We're talking about the 14th Amendment. Section
I am
1.
taking a 5-minute break. We are
Your
in
Honor,
recess.
I don't agree to a estoppel. I don't agree to a
estoppel.
estoppel. Your Honor, as a
Seated, the jury is.
Your Honor, it has yet to be proven for the record. And upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it further.
Are you going to honor your oath of office?
All rise.
So I'll take that as a tacit agreement that you're not going to honor your oath of office.
All right, I'm going to have to excuse the jury. Mr. Brooks, I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You are forfeiting your right to be present in this courtroom. Unless you can promise me right now you'll respect the prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks, I very expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to me that when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet, sir?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
if they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have
All
I
right,
acted
he
in
refuses to answer the questions.
acted in
I have
dishonor,
given
Your
him
Honor?
an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor, have I acted in dishonor?
Thank you, everyone. Please be seated. The record should reflect that Mr. Brooks has been placed in the other courtroom. He is presently on mute so that I can make a record. I do need to confirm that the audio and visual equipment and system is working. I am getting a thumbs up from the bailiff. I'll just ask Madam Clerk to confirm with the clerk that's over there as well. I would note Mr. Brooks has the headphones on. This court certainly doesn't take pleasure in removing Mr. Brooks from this courtroom once again. We are at an important stage of this proceeding where the court needs to instruct the jury concerning all of the law that will guide them in their deliberations. As I've put on the record previously, the total pages comes to 107. I will be reading this morning through page 73 prior to the parties given the opportunity to make closing arguments, and then reading from pages 74 to 106 following that. It is
Petconomics Savings Lesson 12. At Petco, better care for your pet means more savings for you. Now the ball's in your court. Vital Care by Petco makes it easier and more affordable to care for your pet. Petco. Healthier pet, healthier budget.
very important that the court do this without interruption. Yesterday, this court held a jury instruction conference where both parties had a full and fair opportunity to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include, as well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. The court spent the better part of 25 minutes this morning with Mr. Brooks raising issues and prior rulings that this court has spent an abundant amount of time on, including subject matter jurisdiction. He continues to claim he did not consent. That's been noted for the record. He continues to claim that he has a limited or no understanding of prior rulings and decisions of this court. I repeatedly advised him I would not be revisiting these issues, that I wanted to go forward with the jury instructions, and repeatedly warned him that any interruption once the jury came out would result in his removal from the courtroom. Again, I take no pleasure in doing that. I prefer that he be here, but frankly, the decision I made here today, with the speed at which I made the decision here today, is not only to preserve the dignity of these proceedings, but to do so in a way that avoided the court admonishing Mr. Brooks in front of the jury. This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come back. That, of course, is always something that I will give him. As soon as I make my full findings, I will pause, and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made this morning to remove him is based on the authority from Illinois versus Allen. I'd also note that State versus Anthony talks about the Allen decision along with State versus Vaughn. Those are two state court decisions. Clearly, even though Mr. Brooks was using a mild-mannered tone of voice, he directly disobeyed the court order that he not interrupt once the jury was brought out. He did that immediately upon the first juror walking in. I believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that should he interrupt during the jury instruction phase of this trial by either objecting or raising issues that have no bearing on the advisement to the jury by this court of all of the jury instructions, I will consider admonishing him in the presence of the jury or simply removing the jury so that then I can admonish him and then making the appropriate record. All right, with that, since he's asking to come back, we will take a pause, we'll recess, we'll come back in when he is set up in this courtroom. Thank you, everyone. Thank you, everyone. Please be seated. I'll have the jury brought out then. Record to reflect, we are all back in this courtroom.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before
Absolutely
the jury's
not.
brought out,
Absolutely not.
is that a tacit agreement that you don't have to answer those questions as a public servant, Your Honor? So are you going to act in dishonor?
Mr. Brooks,
Are you going to act in
I've
dishonor?
already addressed your requests.
It hasn't been proven for the record, Your Honor.
The jury is on its way,
They're not out yet, though.
but they're on the way.
You held me in contempt.
I'm not
You held me in
addressing these
contempt
matters,
before-
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in
you're
any way?
back in this courtroom at your request. The jury is coming
I
up.
never should have
Please
been.
be respectful of their time.
I
and of this
have
process
been. They weren't
and
even
the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks,
before they came out.
You're
Have I-
just
am I
attempting
acting
to
in
disrupt
dishonor?
the proceedings.
Am I acting in dishonor? So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right, the jury
No
is
jury's
not
out.
Mr. Brooks,
No jury's
go to the
out.
door.
I was trying to
Mr.
address
Brooks,
this
they
before
are
they
right
came
outside
out.
this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out.
And-
if you
and you're
say
making-
one word when that door opens,
You're making a tacit
then
agreement.
you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're going to hold me in
All right,
contempt?
the jury cannot come in. Never mind.
Are you going to
All
hold me
right,
in contempt?
Mr. Brooks is going to be removed. We're in recess until that
How
can
am
be
I, how am I
accomplished.
acting in dishonor?
Thank you, everyone. Please be seated. We are back on. The record appearances are as they were before. The record to reflect that Mr. Brooks is now in the other courtroom. I currently have him muted so that I can add to the record. I have confirmed he can hear and see as well. I would note he does have the headphones on while in that courtroom. He just lifted them up as well, or at least part of them. This court has previously relied upon the U.S. Supreme Court case of Illinois versus Allen, wherein the United States Supreme Court indicated it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle such a defendant, including 1, bind and gag him, thereby keeping him present, 2, cite him for contempt, or 3, take him out of the courtroom until he promises to conduct himself properly. I understand Mr. Brooks is waving to the court. I'll address that momentarily. But the bottom line is there is a history of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note at no time during this case has jurisdiction ever been challenged when he was represented by an attorney. So I warned him. Given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions. I will unmute him so that he can indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Can y'all hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiriting remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful. For the record. And again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother. How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was done by the prosecution. I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am going to bring the jury out, Mr. Brooks. If you want to come back into this courtroom, you need to write your request down on a piece of paper, and when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom. Anything the state wants to put on the record?
I have a question, Your Honor. I don't have anything directly in response to Mr. Brooks' last statement.
All right, go ahead.
Yesterday afternoon, when we had the 4-screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do again?
Yes, it is. We can take the witness stand camera and pull it out so that he has a view of the jury box as well. I can't angle it, but I can do that.
And for the record, when you do that, then he can see the jury box. So I would ask that that be done before we.
Please do that, Madam Clerk.
I can't court TV see them too, and I thought we weren't supposed to show the jury. That's why I zoomed it back in.
Well,
Unless they turn it.
it's not on Zoom, and so the court TV would be able to fix the camera on me and not on the screen, so that they don't capture any of the jurors, and they're directed to honor that and do that. Same thing, obviously, with our still photographer. If there are any images captured of Mr. Brooks, as you can see the cameras being zoomed out, you would need to avoid capturing members of the jury.
Thank you, Your Honor. The record should reflect you have zoomed out the camera, and it looks
Right.
like about 90% of the jury box can now be seen in the view if Mr. Brooks chooses to
Right.
do that.
Mr. Brooks, I'll unmute. What is it you would like the court to address?
How can you rule that I don't have the right to be present in the courtroom?
All right. I've answered that previously. I've made my findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself. And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.